Good morning, everyone. I would like to extend a very, very warm welcome to everybody here this morning. A warm welcome to the Corporate Relations Division webinar on bridging the gap between theory and practice, regulating the private security industry. My name is Lauren Dill. I am the Community Engagement Academic Leader in the School of Applied Human Sciences. And I'm here today to represent the school and to engage with one of our key stakeholders, CIRA, in the webinar today. And thank you so much for being with us. I'd like to extend a very warm welcome to Professor Fikile Mazibuko. She's with us today as the Interim Senior Director of Student Services at UKZN. Professor Mazibuko has served as a social worker and social justice activist in alternative organizations and coalitions. She has been in academic and senior executive positions at the University of KwaZulu-Natal, the previous University of Natal, as well as Zululand. And during these periods, she played a vital role in organizational stability, curricular and infrastructural development, and increasing access to education and promoting exchange of new knowledge. In 2014, Prof was appointed Emeritus Professor at the University of KwaZulu-Natal, and she supervises postgraduate students and serves on postgraduate mentoring programs. Professor Mazibuko was appointed as a council member of KwaZulu-Natal Museum in 2008 and became the council chairperson in 2015. In January 2016, she was appointed as the chairperson of the Private Security Industry Regulatory Authority, CIRA. And so it is very, very encouraging that Prof is with us today. And with that, Prof, I'd like to hand over to you. Thank you.
Thank you, Prof. Dill, for the kind words. Good day and good morning again. On behalf of the Vice Chancellor and Principal, Professor Nana Popoku and the University of KwaZulu-Natal, it gives me a great pleasure to welcome all of you and everyone to this important webinar on regulating the private security industry. A very special welcome to all participants, just to echo your words, Prof. And it is heartwarming to see women featuring very prominently on the panel, especially since this industry has previously been male-dominated. I would also like to extend a very special welcome to the multidisciplinary team and experts from CIRA. Our facilitator will tell us more about them, Mr. Stefan Badenhost, Mr. Divoko Snyaho, Lindiwe Kaluza, our alumnus, Mr. Yanni Sambo. And also, I would like to acknowledge and welcome two members of the panel from the College of Humanities, Mr. Ngosing Pile Mbele, a lecturer in the discipline of criminology and forensic studies, and Ms. Makosi Nomatemba, also a lecturer in the same discipline. She is our facilitator for the day. Also, may I extend a special welcome to members of the executive management team who are with us this morning, members of Senate, the professoriate, key actors in the private security industry, academic and staff, and other professional staff, the SRC leadership and students of UKZN, the UKZN alumni, the media, and all distinguished guests. Just briefly about CIRA. CIRA has a very complex legislative mandate, which is clearly outlined in the Act. And the legislative mandate, as I've said, is clearly outlined in the CIRA Act. Also, CIRA has primary objectives that are to regulate the private security industry and exercise effective control over the practice of the occupation of security services providers in the public and national interest and the interest of the private security industry itself. Certainly, The private security industry has grown considerably in recent years in both strength and stature, and their place in society is firmly entrenched, with every indication that this will continue in the years to come. One only has to recall the important role that they have played during the recent July unrest to understand the importance of them supporting both the public and law enforcement in what can be best described as the thin blue line. Just briefly, CIRA is also very much entrenched in educational aspects, training and education. When one looked at their key strategic and operational milestones in the last 10 years, one could just highlight a few things. That they have a very strong research and development unit, which was established in 2012. They've participated in the International Association of Security and Investigative Regulators in 2019. They have partnerships with international development research centers across the world. This has been going on between the period 2012 and 2015. They've collaborated with the Geneva Center for Security Sector Governance and hosted a workshop on sharing good practices. This was one of their highlights in 2019. And they have very strong partnerships with some of the South African universities. I'll mention in particular, that's where they've got an ongoing program on private security service law, started in 2016, and I think it's coordinated by Dr. Kametse. They also had an MOU with the UNISA, working primarily with the School of Governance and the criminology department at that university. They have a working relationship with the Nelson Mandela University. They also had a very strong working relationship with UCT, University of Cape Town. So you can see that they are not only about regulating the private security industry, but they also are about ensuring that appropriate skills and competencies are acquired by staff within CIRA across the country and within the industry itself. Between 2012 and 2019, CIRA, through its research and development unit again, has completed at least 5 major research studies. These are the ones I'm just highlighting amongst the many. And they also have done 4 major surveys and generated 3 policies relating to the industry. Because of its strong research and training component, it continues to collaborate not only with South African universities, but also with other international universities and other international bodies, including here in the continent, have actually used CIRA as a point of reference when they establish their own regulating bodies in the continent. Ladies and gentlemen, I can go on and on, but may I, with these few words, say welcome, a very warm welcome to today's proceedings, and I hope we will all benefit from this webinar. Thank you.
Thank you very much, Prof. Mazibuko, and thank you for sharing with us or introducing to us the vital work that CIRA is doing in keeping us safer, but also importantly in skills development. It's very warming. Prof has already briefly mentioned our panel of speakers, but let me just quickly maybe tell you the order in which people will be speaking, and also just to let you know that each speaker will be given 15 minutes to present. And we have Ms. Nomakosi, who will be chairing the presentations. So she will be letting you know if you're going a little bit over time. And as well as if everyone could please, if you have any comments or any questions, if you could either jot them down on a piece of paper, and you can ask these questions after everyone has spoken, or you could use the chat function as well. So I think that as Prof has already introduced all of our speakers or mentioned our panelists, I'm simply just going to introduce the first speaker, and Norma Corsi can take over from there. So I'd like to welcome as our first speaker, Mr. Stefan Badenhorst, who is the Chief Operations Officer at CIRA, and his topic is on Private Security Industry Regulatory Authority. And thank you very much, Mr. Badenhorst. We look forward to listening.
Thank you very much, Program Director, and good morning to everyone. It's a very privilege and honor for us to be invited to be part of this webinar. I think it's also extremely pleasing for us to hear from Prof. Masibuko. You know, we know Prof. Masibuko very well, as he indicated, as well as he served as our chairperson of council. So we are very familiar with Prof's passion in regulating the private security industry and the support for CIRA. I think, Program Director, I know I only got 15 minutes and I'm going to try and stay in time. I've been accused before of liking the sound of my voice. So I tend to go into a little bit detail, but I'll some of the slides I'll just be highlighting as maybe as self-read. And some homework for those, so hold on to your chairs. Let me see if I can do it within the time frame. My presentation is basically going to deal a little bit with the overview of the private security industry in South Africa. What does it actually entail when we talk about the private security industry? And then I'll highlight a little bit the overview of CIRA itself as the regulator responsible for the regulation of the private security industry. Now, if we look at the private security industry itself, it's still one of the fastest growing industries in our country from a human resources point of view. There's a number of reasons why the private security industry continues to grow. People are taking more responsibility for their own safety and security. Sometimes there's a mistrust that the police or the public police can actually ensure that their rights are not infringed in terms of safety and security. So there's a great appetite for private security, which results in the annual turnover to be over 200 billion rand a year. So it's a significant industry in this country. It's got significant growth, and it obviously presents opportunities for entrepreneurs and investors in marketing the service where there's significant demand. If we can just consider the kind of state private, state institutions that use the private security industry is quite significant. Now, when we look about the security industry in itself, and the legal basis for the existence, you'll find that it derives from the Bill of Rights. Where everyone in South Africa has that fundamental right to human dignity, life, freedom, and security, and not to be deprived of property. Now, we know these rights are afforded to the state agencies like your South African Police Service, but it also provides for legitimate self-protection, and there the private security plays in that space where citizens have the right to protect themselves through legitimate means, and the security industry then becomes an instrument for lawful individual and corporate self-protection. And I think it's known that the importance in the fight against crime is self-evident. Now, if we think about the role of the private security industry, it's generally to provide increased protection to the rights of property and person. We know that there's other state agencies like your police service and other entities that fulfills a function of providing protection to the citizens of the country. So the private security industry provides that additional increased protection and more personalized protection. And I think obviously one of the distinctions is that they've got a profit motive, and they're contractually accountable to their clients, where obviously the public police accounts to the state. There's some obviously a criticism about the private security industry, because generally those that benefit from the private security itself is those that can afford it. So, from a regulator's perspective, it's our view that the private security industry has got a far greater socio-economic and responsibility towards all citizens in the country. And, there's numerous initiatives as far as that is concerned to ensure that the private security industry don't just focus on their paying clients, but also at the industry or the citizens at large in the areas which they work and live. So generally, the industry's role is to prevent crime from taking place in the first place in a proactive manner. It's a rather problem avoidance than apprehension and prosecution, which is the domain of the South African Police Service. Now, I'm not going to go much into the history. As a regulator of the industry, we've been there for quite some time. And the era before 1987, we referred to as a non-intervention model for regulating industry, where the industry was more, grouping themselves and to ensure voluntary adherence. And there was obviously other pressures in ensuring that the industry complies to some form of norms. But in 1987 saw the first publication of the Security Officers Act, and we referred to it as the minimal regulation model. Although the legislation was there to ensure that the private security industry is regulated, the board that exercised the control over this regulated, the Security Officers Board, consisted out of the members of the industry themselves. There were no state representatives on this board. So we referred to it as a minimal regulation model. It was really the start of regulating the private security industry. Up until 1997, there were more movements towards state regulations, and the object of regulation included that the industry must act in the public interest and were required to report to the Minister of Police and advise the Minister of Police on future regulations, which ultimately saw the establishment of the Private Security Industry Regulation Act, which established us as the CIRA, and repealed the previous Security Officers Act. And then the objects of regulations included that of national interest, public and industry interest. And a very significant change was the industry was no longer part of the governance or of the regulator. It was replaced by a 5-person council, which were independent members from the industry. So the industry itself, currently in terms of the CIRA system, council is not represented on the body, which was obviously not accepted widely by the industry, but we believe it was a very, very important move to ensure that the regulator is independent from the industry. Now, just a general view of the industry, if we look at the legal sense, we're a public entity. We're Schedule 3A in terms of the PFMA, but we're an independent regulator. We're self-funding. Government views the regulation of the industry as key national importance, but the policy position is that the industry will fund its own regulation. So we impose levies on the industry to fund us as a regulator, and ultimately we're a law enforcement agency. We exercise control over the private security industry using our statutory powers in terms of the CIRA Act. This is just a broad, I know it's a little bit small, but it's just a broad organizational structure. We account obviously to Parliament, to the Portfolio Committee on Police, through our executive authority, which is the Minister, and then we've got our council that's appointed by the Minister in consultation of Cabinet. They are supported by a number of subcommittees in terms of governance, it's very effective, our governance oversight. The CIRA is one of those state entities, although we self-funded. We get clean audits. We just achieved our 3rd consecutive clean audit, and it was followed by a lot of unqualified audits before that. And then our head is the authorities director, which is our CEO. And then we've got a senior executive structure with the different units, which some of the departments will go into. In terms of our vision is that South Africans have confidence in the legitimacy, occupational practices and transformation of the private security industry. And then our mission is effective regulation of private security to enable professional and respected security service providers. We have core values, which is integrity, excellence, and Ubuntu, and we hold our staff accountable for towards these values. Now, Prof. Masibuko already indicated a little bit about our mandate. Ultimately, we are established to ensure that we exercise effective control over the private security industry in the public, national interest, and the interest of the private security industry itself. So ultimately, we serve the interests of those three: the public, so the industry that do not impose or threaten the or infringe the rights of the public; the national interest. We know the private security industry is a significant private policing force in a democratic state. So we need to ensure that this industry itself, that's well armed, well equipped, do not pose threats to the democratic state. And then ultimately, we want to ensure that the industry itself is benefited from regulation, ensure there's professional standards, that they're legitimate. We look at their registration, ensure that they're competent, and ultimately to ensure that everyone is protected in the end of the day, but the private security industry in itself is uplifted through us as regulatory body. There's a lot of functions in terms of our legislation, but I think key functions is obviously that we want to register. Everyone that plays in this space need to be registered as security service providers, and part of that registration is that we screen them to ensure that they are meeting all the requirements. And then we also, have statutory training standards that the industry need to meet in order to be registered with us. And then ultimately, we inspect and we investigate and we prosecute those who break the law. And Jan Sambu will be dealing a little bit with that. And ultimately, through our research as well as which Prof. Matsibuko also referred to, we also advise the Minister of Police on any shortcomings in the legislation and areas where we need to improve the CIRA legislation. Now, if we talk about the industry, private security industry, the first thing that always comes to mind is the guarding sector. Yes, that is true. The guarding sector is the biggest sector in the private security industry, but our net or the net is thrown very wide in terms of who's categorized as a security service providers. It's the guarding sector, definitely, but it's also close protection, your response industry, your asset and transit industry. I think most of the people are very familiar with that, but it also includes your event security, at safety, stadiums, those event security officers, control room operators. Then you have manufacturers of bugging devices. They need to register with us, your locksmith industry, and then your electronic industry, which is a vast industry. This is your alarm systems, access control systems, CCTV, metal detection, X-ray inspection, all of those categories. People involved in installing, servicing, repairing those equipment fall within the ambit of our legislation, both business and individual, and they need to register. And then your security trainers, private investigators, your consultants, and even in-house security. People, businesses employ their own security officers to fulfill any of these functions. They are categorized as security service providers and need to register. Now, if we look a little bit in terms of the statistics, we have about 2.6 million registered security officers on our database and just over 11,000 businesses. And the next slide just give a bit of a breakdown of those that's active currently in the industry. In terms of businesses, about just under 11,000 businesses, with the majority in Gauteng, followed by KwaZulu-Natal, and then the Western Cape and Limpopo of 9%. This geographic spread changes over the years, and it obviously follows a lot of reasons. Crime is mostly, where we see an increase in the security industry moving in certain provinces. Now, if we look at our security officers, we just have under 560,000 registered active security officers. It's almost 3 times the size of the South African Police Service. So it's a significant private force operating within the democratic state, with 37% in KwaZulu-Natal, in Gauteng, followed by 18% KwaZulu-Natal, and then the Western Cape. This is just a bit of a graph just to show the increase over the few years. You'll see it's starting to level out a little bit in the last few years. The growth is not so aggressive anymore, but that's more to do with the employment figures. The industry is still growing, but the face of the industry is changing a little bit as the electronic security component plays a bigger role. As technology takes over, obviously the need for warm bodies on the ground is reduced, but the industry still grows. As far as business are concerned as well, very, very competitive cutthroat industry. So it's more or less stabilizing about 10, 11,000 businesses. But, as businesses, increase their margins, you'll tend to find bigger businesses absorbing those smaller businesses through acquisitions. Now, just a CIRA footprint, and we've got offices here, our head offices in Turin, then we've got offices in all our provinces, but we do have gaps in terms of our footprint. And I'm pleased to announce that we are finalizing our digital, platforms for registration and for businesses as well as individuals for the renewal of their certificates. So a lot of our footprint that we actually wanted to have across the country is no longer really necessary as we move also to and make use of 4IR, ensuring that we digitalize most of our licensing requirements. I'm talking, if we look at, and you're welcome to also download the CIRA app, is very helpful. You can go to the app stores and download CIRA app, and you can actually see that's everything that's there. And there's different, information. You can even verify whether business security officers are registered. It's very helpful. So we'll urge anyone that's interested in CIRA, visit our website and also download our app. We are aggressively rolling out the digital transformation strategy over our next 5-year strategic planning period. As I mentioned, we're starting from about next week. We'll launch those platforms. And then there's a number of things that we're going to digitalize over the next 3 years. And this is just some of our partners. Prof also spoke about that. We've got a number of partners within the government sector that we work with on a regular basis. Obviously, State Security Agency, the South African Police Service, they are valuable partners in terms of ensuring that the industry acts in the national interest. And then we also have some global partnership with PCAF in terms of research. Prof also highlighted that we play quite an active role in advising other countries on how to regulate the industry. We're quite a leader in the world as far as that is concerned. A lot of the European countries benchmark their regulators on CIRA. We are quite advanced in terms of our regulation of this industry, and they use us as well, to see whether they are on the right track. That's in a nutshell who we are, Chair. I think I'm 1 minute over time, but thank you very much for the opportunity. It's really appreciated. Thank you.
Thank you so much. I'll be introducing our second speaker now, Mr. Jen Sambo. He's the Acting Deputy Director. His topic is on the practical aspects of regulating private security industry. Mr. Sambo, you can go ahead.
Good morning, everyone. Hello, am I audible?
Yes, you are.
Okay, thank you. Just wanted to share my, just wanted to check if you could see my presentation.
It's not showing yet.
Okay, let me, is it now visible?
There we go.
Yes, it is.
Thank you. Oh, there's so many things on my screen just for now. Okay. Good morning, Professor and esteemed guests that are on the platform. I would like to firstly apologize for joining late. Technically, I was just having some challenge where the area where I am. As our executive Stefan has mentioned, some of the areas I won't be covering more because he's already covered that. The topic that I've been requested to talk about was the practical aspects of regulating the private security industry. Prof, and everyone on the presentation will cover the composition of law enforcement division, the applicable statutes, that we are applying or we're using as law enforcement to regulate the private security industry. The activities performed by the law enforcement division, that is, I think that's what would be mainly the issue, how practical, which aspects are we doing. I'll also cover a slide in respect to the challenges that are faced by the law enforcement division regulating the private security industry, both internal as the division and also maybe the industry itself. And then lastly, in bridging this gap between theory and practical, what are the maybe some of the things that we identify as possible solution to the challenges that we are having. The law enforcement division is it's one of the programs within CIRA. And as Stefan has indicated, our function is to ensure that the industry role players comply with applicable legislation and regulation standards that are set by our regulations. And then what is very important is our division has two units, that is the inspectorate division and the legal services, which comprise of prosecutors, where there will be prosecution of the work that we're doing. Stefan has already covered the area for everyone that mainly in theory, people have been seeing that the duty to protect the citizens of the country lies with the state. Hence, you see the South African Police Service and other law enforcement agencies. But over a period of time, that theory is now shifting. Hence, when you get to Section 199 of the Constitution, it also makes provision that there may be other forces that will be there to protect the citizens. Hence, the CIRA Act is now enacted to make sure that those other forces that are not found themselves being under the definition of what is a service in terms of the Constitution are legalized and are controlled. Hence, you find this CIRA being there to make sure that all those private entities, the security businesses that we regulate are governed by this legislation. So for us to make sure that what the Act, its mandate is fulfilled, we've got inspectors of the authority that are appointed to police the industry. They are appointed in terms of the CIRA Act, and the inspectors have powers that are conferred to them in terms of the Act and also in terms of the Criminal Procedure Act of 1977. So basically, they are peace officers to make sure that we enforce the legislation that I will be covering. So for us to be able to enforce and regulate the industry, then there are certain pieces of regulation or legislation that we enforce. For example, the CIRA Act, which empowers us as the regulator, which has the code of conduct, the regulations, the improper conduct inquiry regulation, where we deal with prosecution now after the aftermath of the actions of the security service providers, the training regulation that will cover the what form of standards and training requirements that should be fulfilled by the security service providers. The funding regulation pertaining to the funding, as we are a self-funding institution, then how we getting our funds. The regulation relating to appeals and exemptions, you find that there are parties that they've been found guilty, and in terms of the process, and they need to appeal. What then happens, or those who feel that they should not be regulated by our legislation because they are regulated somewhere, then exemption part will play in there. We've got also other legislation that are coming from other institutions, like the Firearms Control Act of 2000. That is very important because you find that the industry, the way it's so big, and there are firearms that are being used by the security service providers, and there's a need for that to be controlled. I think the recent cases of KwaZulu-Natal, Phoenix, where it has been, there's been allegation that there were firearms used, some of them, I think from the minister and from the media, where they've been confiscated by CIRA and South African Police Service. So hence that regulation, that act is very important for us. The Basic Condition of Employment Act, which deals with the conditions of security officers that are employed within the industry, the bargaining council agreements, any other legislation that will affect us. The Criminal Procedure Act of 1977, I just wanted to make a correction there. We wrote 1997, but it's actually 1977. The National Key Point Act, which now I think is going to be very soon, even where I am, then we're talking about it today, is going to come to an end and be replaced by the new act, which is the Critical Infrastructure Protection Act and the Performing of Animal Protection Act. members within law enforcement, then we've got a strategy that we use to make sure that the industry is regulated properly. Then the strategy that we use as law enforcement has a compliance model for those businesses or service providers that they know the legislation, they just need to be assisted in complying with it. Where you find that there will be more voluntary or compliance in respect to applicable legislation that are there. So if we found any challenges that the industry is having, then we'll offer education, and where there are minimal or minor transgressions, then form of warnings and the improper and disciplinary steps that may be taken to correct the actions of the service providers is applied. But in respect to the enforcement model, it's a model where we apply into security service providers that are either registered or not registered, but they don't want to comply with the law. They know what the law says, and then they profusely refuse to comply with the law. So actions that we do there is more mainly of investigations where there will be criminal cases open against the security service providers and all code of conduct. And that's where also now the actions of those service providers will get to a prosecution process where now penalties will be imposed, heavy fines, or sometimes even the withdrawal of registration. Going back to the functions that is conducted by both these units, as I indicated, there will be business inspections that are done on business to check compliance with those applicable legislation, but we also conduct individual physical inspection on security officers that are deployed on the site, because the Act covers both individuals and service business. We need to make sure that everyone that is deployed as a security officer complies with the legislation that requires them. For example, issues of uniform, issues of wearing of proper uniform, having a card that you can be easily identified with that you are a service provider, and also in case where there are firearms used, that we check compliance with firearms. So, this slide will show all the practical activities that we do as law enforcement. As I indicated, checking firearms. We also have some liaison and operations that will be conducted with other law enforcement agencies like your South African Police Service, where the enforcement of the Firearms Control Act, and where we effected arrested, then they need to transport the prisoners or the suspects to police station. Department of Employment and Labor in respect to other conditions of work. Department of Home Affairs in respect to those security officers that are maybe illegally undocumented personnel that in terms of legislation, they are not allowed to be in the country, or are not allowed to operate the security service program because they are not exempted or registered with SERA. We've got the private sector provident fund, where legislation respect to the protection of the security officers' well-being, that if it happens that they get hurt or they retire, then there's some revenue funds that are stored for them. As I indicated, that within law enforcement, we've got legal services, which comprise with prosecution, but we also have a debt collection section there, because the Act, as indicated, we are self-funded, then the industry needs to pay fees to the authority. Those who cannot pay fees or they fail to pay fees, then we've got a division that will make sure that funds are collected. Every act that we conduct inspection or investigation will end up with a code of conduct that will be taken to prosecution. So that will be, it's open by the inspectors that are investigating those cases. So this slide covers all the activities that I've already mentioned about what types of inspection focus areas we check in, that is compliance with legislation, ownership, and that the service providers report changes that they need to report to the authority in time. As I already covered that with my discussion, these are compliance areas that we check with security officers, that the information that they provided to us previously is still correct, their registration status, the uniform compliance, ID, and firearms. Within our legal services, the practical aspect that we do is prosecution of those non-compliant service providers, and that will also we've got our legal services that will give advice to also our investigators when doing investigation. If we get to a situation where we need advice in respect to the cases that we're investigating, how to compile charges, And then also maybe before we go for a testimony, to give testimony, how we are being advised in respect to different cases. Because what has changed now is previously we used to, I think a majority of the cases were in respect to only to registration and training status, but the industry has evolved so much that the charges that we found today against service providers, in most cases somewhere, they'll include issues of identity theft and also issues of other things. So we'll need more of legal service to provide that legal support to the inspectorate. We also got some committees that are lying within law enforcement, and these committees will assist also both prosecution and inspectorate in respect to the actions that should be taken to non-compliant service providers. I think giving an example of KwaZulu-Natal recent cases of lootings and disruption and hoarding, you find that there are security service providers, being businesses or individuals that are implicated in those acts. And what will do, the subcommittee will receive complaints and investigation reports from the inspectorate into the actions. Then that's where now it will be discussed and to determine whether such service providers should be issued with letters of intention to suspend or to suspend them pending the finalization of the case. And also once the cases have been dealt with in terms of prosecution, then the same committee will be the one that will be sitting to confirm the penalties that has been issued against such security service providers. In respect to those who have been found guilty, the improper conduct regulations also comes with penalties that can be given to the offenders. As I indicated, that from that model of compliance and enforcement, so depending on the nature of your offense, then the appropriate penalty will be issued. And penalties that we've got in terms of the improper conduct include warning or reprimand, suspension of registration, or withdrawal of registration, that is your license, the license to trade as a security officer or as a business. You can also impose a fine of not exceeding 1 million rand per count or a combination thereof. And what is very important, you find that some of the offenses that are being conducted or committed by the security service provider are both, you find that you can impose, we can institute criminal cases and code of conduct. So it's not like we're duplicating the charges or you are being punished twice, but the improper conduct regulation allows that provision that in some areas, for example, a business that is operating while not registered or a security officer that operates while not registered or trained. I won't cover, this is just the activities that we have done in respect to the last financial year. I think everyone will read it at their own time. Challenges that we found, and I think that's where we're coming, sometimes you find that because the law is changing and situation, then there may be legislation gaps in respect to the current legislation or regulation that needs to be looked into. Like, for example, issues of cybercrime. That's something when SIRA started or SOB was not there, but it's something that is new. The issue of locksmithing, because now we are talking about codings, and also actions like that are done by the Red and Security Service, where you find that there is demolition and evictions, which is an issue that is being contested too much, whether to say is it security service or not. Also, the new challenge that we found in prosecution is the issues of prosecution, where you find that the most of the cases now it's about identity theft, where some security officers are assuming the identities of the registered security service providers or officers in South Africa. Another challenge is cooperation between other law enforcement agents, more especially with NPA.
Apologies, Mr. Sambo. Can you please wrap up?
Okay, thank you. So yeah, I think these are the challenges that I named both internally and externally. And lastly, I think what we would see as a positive thing is if we can have development courses in respect to the challenges that are raised above there, and also the periodic refresher training for our law enforcement officials, more especially in areas of investigation, statement taking, and crime scene management. I thank you, Chair. Thank you.
Thank you so much for the wonderful presentation. Before I would like to welcome Professor Gopal. I see she's just logged on. Our third speaker would be Mr. Tebogo Sinago, the Acting Manager of Research and Development. His topic is on research development units on CIRA. Tebogo, you can go ahead.
Sorry, you're on mute.
Tebogo.
Oh, thank you very much, Norma, and a very good morning to you, ladies and gentlemen, who are present in this platform today. Before I even dwell into my presentation for today, I feel that there is a need for me to reiterate why we are having this webinar today. As CIRA, we are in the process of negotiations where we are looking forward to having a memorandum of understanding with the University of KwaZulu-Natal, in which we want to encourage more students to undertake studies on private security industry as a topic for research. So we are in the process of negotiating where eventually we'll have a memorandum of understanding which will be beneficial for both the authority as well as the university. And as part of engagements and ensuring that we understand each other as potential stakeholders, we requested that we have a conference or a webinar in which we'll be able to engage with each other and get to know and understand each other as stakeholders, Norma and all the members who are present here today. I'll be presenting on the research and development as a unit, indicating where do we fit into the scheme of things here at CIRA, because one might ask a question, how does CIRA as a regulator, which its core function is to regulate the private security industry, to have a research and development unit? Indeed, there is a need for any regulator to have a unit doing the job that we are doing in order to ensure that we stay abreast with the developments within the industry as things are evolving, as Mr. Badenhorst alluded earlier on to say that the private security industry is changing in its phase. So we'll be detached from that reality if we don't undertake studies to understand what is happening in the private security industry. So as I said, mine is just to indicate where do we fit into the scheme of things. And I have to indicate, Norma, I hope that I'll not be eating into much of my presentation time. You end up cutting my time. I have to indicate that seeing the theme that we've came up with, which is to ensure that we bridge the gap between theory and practice. We deliberately roped in the acting DD law enforcement, Mr. Sambo, to come in and give us a presentation on the practical aspects of regulating private security industry, of which I think he did very much well in understanding that our work at the end of the day is not just a mere rhetoric, but it goes into something that is more practical than anything else, because as a unit, we are a support structure within the private security industry. Let us look at the overview of our presentation. I'll deal with the introduction part of how the research and development unit started at CIRA. I will also address the issues relating to our current structure, the legislative mandate, which ensured that the unit is established, the purpose of research and development units. I'll spend the better part of time in my presentation giving you the research projects that we have undertaken over the past 9 years since the unit was established. And in fact, this is the reason why I'm having this presentation, because I would have really loved to present without the slideshow, because PowerPoint has got this tendency of capturing one's presentation. You end up limiting your knowledge to what is in the presentation. So I'll spend the better part of my time giving you the overview of the projects that we have undertaken over the past 9 years, We will also look at the ongoing collaborations with other institutions that we are having as the regulator. And I'll also give you the current research projects that we are undertaking as a unit. Then I will conclude my presentation. So as Prof. Mazibuko indicated, the Research and Development Unit of CIRA was started in the year 2012. When the then executive saw the need to give effect to Section 4D of the Private Security Industry Regulation Act, which is the legislation which established CIRA, when they roped in Dr. Sabelo Gumedze, who happens to be the head of the unit to this day, to come and undertake studies within the unit within the authority on private security industry topics. And one of the biggest and first projects that was done by the unit was the monograph, which was focusing on promoting partnerships for crime prevention between state and private security providers in Southern Africa, which was way broader because it focused on 4 SADC countries, which are Botswana, Namibia, South Africa, as well as the Kingdom of Eswatini, in which various scholars were roped in to undertake studies in those countries to look at the crime prevention relationships between the state as well as private security industry. And Dr. Sabelo Gumedze himself was the editor of that monograph, which was funded by IDCR, and it was produced for the Private Security Industry Regulation Authority. And I have to indicate that over the years when we collaborated and engaged with various regulators of the private security industry, we have since realized that with all those that we have engaged with, starting from North America, South America, as well as Europe, we remain the only regulator which is having a dedicated unit which ensures that as the regulator, we don't get detached from the realities of what is happening on the ground by ensuring that we conduct studies and understanding what is happening as the industry is evolving on daily basis. So over the years, the unit has grown from being a one-man show from the time when Dr. Sabelo was roped in to where it is now. And let us look at the organogram of the research and development as things stands currently. The unit reports to the Chief Operations Officer of the authority, which is Mr. Stefan Badenhorst, who presented earlier on, and the unit remains managed by the senior manager, who's the head of the unit, Dr. Sabelo Gumedze, and myself, I'm the acting manager within the unit, whilst Dr. Gumedze is engaged with other authority activities in which he is the acting DD training and communications. We have a team of researchers starting from the left. Here we have Ms. Nomno Tozama, who's a researcher within the unit. This is me, the acting manager of the unit. We also have a lady who's running the admin support of the unit in Tabisem Parker. We also have a researcher here, Ms. Londiwe Kaluza, who happens to be a graduate of the University of KZN. We also have Mr. Hlonipani Kulu, who's a researcher within the unit. And we also have Mr. Njabulo Mkwanazi, who is also a research intern within the Research and Development Unit. Now, let us look at the legislative mandate which gave birth to this unit. According to Section 4D of the Private Security Industry Regulation Act, the authority amongst its functions has got the responsibility to conduct an ongoing study and investigation of the rendering of security services and practices of security service providers in order to identify shortcomings in this act, which is the Private Security Industry Regulation Act, and the Levies Act or any other policy or rule drafted in terms thereof, and to deal with any evasion, abuse, or violation of the procedures or principles contained in this act or the Levies Act or any other policy rule made in terms thereof. That is why earlier on I indicated that when the unit was started in 2012, then executives saw the need to give effect to this provision of our legislation to ensure that we conduct ongoing studies in order to understand what is happening in that space. Now, let us look at the function of the unit. The function of the unit in brief is to undertake research that provides relevant insight on how SERA's core business activities can be enhanced in order to achieve excellent service delivery. The question is, how do we do that? We produce research reports which informs the development of policies, and the policies informs the development of regulations, and that is where the practical aspects comes in. When the regulations are developed by our legal unit, they are being handed over to the law enforcement unit, where in which Mr. Sambo and his team will ensure that there is compliance with what is in the regulations as well as the legislation. That is how we fit into the scheme of things. Our research reports at the end of the day are not just mere rhetoric, but they come from where they are to ensure that we inform the development of regulations which assist the authority to even become better in its service delivery to those that we are regulating. Now, let us turn our focus into the research projects that we have undertaken over the past 9 years. As I indicated earlier on, the first project that the unit undertaken was the monograph, which was focusing on the promoting partnership between state and private security industry. And we also had a study that Londiwe will be presenting on later on, which focused on the rendering of security services in the institutions of higher learning in South Africa, which was largely influenced by the Feast Must Fall movement, which looked basically at how security officers conducted themselves around students who were protesting back then. We also had another study that was undertaken by Londiwe, which focused on the rendering of security services in certain public schools within the province of Gauteng, which was largely influenced by the incidents which were reported nationwide in the previous years, where in which there were cases of kids being killed and raped and victimized in schools around the country. And some of the projects that we have undertaken also include the study on car guarding. I would like to believe that every one of us in this platform today have managed to experience or engage with car guards in one or the other in our lives. And from regulatory point of view, we undertook a study in which we focused on what is really happening in the space where the car guards are operating. And as I indicated, from a regulatory point of view, because from other angles, a humanitarian might say it is a right thing to give a car guard some tip after they've looked after your car when you are busy doing shopping or busy with other engagements. But from where we are seated, the service which is rendered by car guards is a security service which is subject to our regulation. Therefore, which means any other thing that the car guards are doing should be subjected to the rules and regulations of SERA as per the Private Security Industry Regulation Act and the regulations developed in terms thereof. So if anybody wants to know anything about the regulation of car guards, this is the report to look at. We also undertook a study which focused on the services that are rendered by those protection officers, what is normally referred to as VIP services. There was also a study which we undertook which focused on the labor practices within the private security industry of South Africa. And we also undertook a study which focused on the working animals that are used in the private security industry of South Africa, mainly on the dogs as well as horses that are used to render services. And the report which was produced was called Canine Protection, which influenced the development of draft regulation on the use of animals within the private security industry. And other project that we undertook was a research which looked at the services that are rendered by the private investigators within South African private security industry space. We also undertook a study which focused on the manufacturing, importation, selling, and distribution of security equipment. As Mr. Barenos alluded in his presentation, the various categories of subsectors within the private security include the manufacturing, selling, and importation of security equipment, There was also a study which we have undertaken, which focused on the protection of assets in transit, what is normally in the street language referred to as cash in transit, but our scope was way broader because we do not focus only on cash in transit, but we also focus on other precious things that needs escort of security services whilst transported. And we also undertook a study in one other year which focused on the training standards within the private security industry, with the view of improving the training standards in the private security industry. And another interesting study was conducted which focused on the use of uniform, badges, and insignia within the private security industry. You will almost agree with me that there are security service providers out there which are using uniforms or insignias, which from a distance you can be misled if you didn't check them thoroughly that they are police officers or they are even military officers. There was a study which was conducted around that particular practice, which informed the development of draft regulation on the use of uniform, insignia, and badges within the private security industry. There was a study which was conducted by Dr. Sabelo Gumeze, which focused on the use of firearms within the private security industry, which was named the barrel of the gun, which also informed the development of regulations on the use of firearms within the private security industry, which became very much topical in the past 2 years, where in which some within the industry were alleging that we wanted to disarm the private security industry, whereas, of course, it was not our intention. If you read the report in context, the policy as well as the regulation, you will get to understand how did we arrive at those draft regulations that we have of the use of firearms within the industry. There was also a study which we undertook some few years ago, which focused on the rendering of private security at the sporting events, which focused specifically at special events as a subcategory of the private security industry. There was a study which was conducted by the unit in the year 2017-2018, which focused on the developments of locksmithing as a subsector, where in which it was identified that the locksmithing as a sector has evolved from what was ordinarily just a key cutting issue. Hence, the name of the report is called More Than Just a Key Cutter, where in which today we found the locksmithing to be very much developed to an extent where in which locksmith operators are doing some of the most complex services, where in which they even do transponder services. The key has changed from the ordinary key to an extent where in which people use fingerprints as keys, as well as coded cards as fingerprints, and that is the job of locksmiths, who are subject to our regulation as well. The unit also undertook a study which focused on security consulting as a service. We also conducted a study where in which we focused on in-house security. In the year 2019-2020, we also undertook the study which focused on the rendering of security services within South African airports and looked at the roles which are played by other regulators within that space. And there was also a very interesting study which was conducted by Londiwe Kaluza, which focused on which focused on the protection of endangered species, basically what we call anti-poaching as a security service, and which identified that anti-poaching is way broader than the definition on the street, where in which people focuses on rhino. Basically, anti-poaching services include all the protected species of flora and fauna categories. It's a very interesting study where in which we looked at that. In as much as it is a short service, It focused on that. I can see Noma Kosi is coming in to sabotage me very soon. I'll be wrapping up Noma Kosi, don't worry. And we also undertook a study which focused on the rendering of security services in South African harbors, and also another study was conducted in which we focused on the rendering of security services within the railway space. And finally, we undertook studies which focus on neighborhood watch as a kind of security service to look as to whether this is subject to serious regulation. And also in the previous financial year, my colleagues Ntabise Mpaka as well as Luvokasa conducted a study which focused on the rendering of security services outside South African borders, which is a very interesting study which indicated that there are security services which are rendered by South Africans outside our borders, indeed, including in countries such as Afghanistan. And we also conducted a study on a topical issue in the whole country, which is the Protection of Personal Information Act, to try to understand how is it going to affect us as the private security industry. And also we looked on another study on the punitive measures that are vested upon SIRA by the Private Security Industry Regulation Act. There was also a study which focused on the rendering of private security services in public services. As Mr. Badenhorst alluded in his presentation, that and Prof. Mazibuko, that we have ongoing collaborations with stakeholders. One of the most interesting collaborations we have is the one that we have with the University of the Witwatersrand, in particular the Mandela Institute, in which we are offering a course, a private security services law course as a postgraduate course, of which Dr. Sabelo Gumedze is also a lecturer there of this very interesting course. And I think that is one of the directions that we are looking to take with the University of KZN in the project that we are busy with currently. And we also have a collaboration with DCAF in Switzerland, which in the year 2019 funded one of the very interesting projects in which we gathered the regulators of private security industry in the SADC region, in which we were sharing good practices in regulating the private security industry. And a report was produced after that particular workshop that we held with DCAF. And all these reports, including this one, can be accessed on CIRA's website under Publications, Research and Development. That is where one can access them. Within the current financial year 2021-2022, we are conducting 5 studies. The first one focuses on the impact of the 4th industrial revolution in the private security industry of South Africa. We are also conducting a study looking at the regulation of private security industry during pandemics with a specific focus to COVID-19. We are also looking at the impact of the National Bargaining Council for Private Security Sector on the regulation of private security industry. We are also looking at the regulation of cyber security service providers, and we are also looking at the powers and function, the legal aspects of regulation of private security service providers, and we are also having 4 surveys that we have contracted the external service provider to conduct those surveys with our consumers. And I have come to the end of my presentation, Program Director, and thank you very much for listening to my presentation. Over to you.
Thank you so much, Teboho. That was very informative. Up next, we have Ms. Nkosi Mpilembele, a lecturer in the discipline of criminology and forensics. He'll be presenting on enforcing SIRA Act in drinking establishments. You can go ahead.
I'd like to greet the facilitator, the UKZN team that organized this webinar, the staff from SIRA, all the panelist members and the attendees. As I've been introduced, my name is Nkosi Mpilembele from the University of KwaZulu-Natal, the Department of Criminology and Forensic Studies. My presentation today will be on enforcing the SIRA Act in drinking establishments. I'm sorry, I do not have slides. I'll just talk, and I only have rough notes that will guide my presentation. So the private security industry, as you've heard, is one of the biggest industries in South Africa. It has seen massive growth over the years due to the demand of its services, and the growth of the industry has obviously come with challenges. And one of the challenges that it has faced was that of regulating it. But in comparison with other African states, South Africa is one of the best countries when it comes to regulating the private security industry. And this is likely due to the history of South Africa's involvement in civil wars across Africa and other war-ridden states, which somehow forced the government to develop legislations that would be harsher on mercenarism and other illegal activities conducted by private security companies from South Africa. The focus of my presentation is on a subject that I believe less attention has been paid to by academics and also by SERA as the regulatory authority of private securities. This area is somehow new, and it's an interesting theme in criminological research. I will talk about the importance of enforcing legislation and regulatory frameworks on bouncers in drinking establishments. In my topic, I refer to the SERA Act because it is the main legislation that regulates private securities in South Africa. There are other legislations as well that private securities are subjected to. I will also discuss the role of private security industry regulatory authority in enforcing regulations and compliance in drinking establishments. I will also refer a bit to some of the findings from my studies to make examples and elaborate on my points. Please note that when I speak of my findings, they are based on a study conducted in KZN where I interviewed a couple of bouncers, patrons in drinking establishments, and also staff members from SERA in KZN. So it was a qualitative study, and my aim is not to generalize my findings. And lastly, I will provide recommendations. So what is the purpose or the importance of enforcing regulatory frameworks in drinking establishments? I think the first one that is important is to ensure professionalism. Enforcing regulatory and other legislative frameworks in entertainment venues will ensure professionalism in the industry, which is an industry that has mostly been assumed as casual, as a casual industry. I'm referring to the bouncing industry, private securities in drinking establishments. Bouncers do not see themselves as professionals that should follow the rules and regulations, and they behave in a manner that is equivalent to the standards set by SERA. I conducted a research to study only 5 drinking establishments in Durban. And I found that most bouncers who were interviewed were not aware of an organization called SERA. Some even mentioned that it is the first time that they hear of such an organization. And this could only mean that those bouncers did not undergo the legally necessary routes or steps to attend the SERA accredited training colleges and register with SERA as fully qualified private securities. The bouncing industry is widely known as a male-dominated industry. Most drinking establishments and male bouncers do not believe that a woman can be a bouncer. And this is a problem because this is discriminatory towards women who wish to enter the industry, but are not given the opportunity. And this also contravenes with the Gender Equality Act. Hence, I believe that enforcing the legislative frameworks in drinking establishments will close this gap. It will provide equal opportunities for everyone who wishes to enter the field, irrespective of gender and other discriminatory factors. It is also important to regulate the bouncing industry for better opportunities in terms of salaries and also other employment benefits. In the study I conducted in Durban in nightclubs, Bouncers that were interviewed mentioned that they were paid way less than expected, and they further received no employment benefits such as health insurance, etc. So this is largely due to no training certificates and not being registered as private securities. So enforcing the SERA Act will encourage untrained and unregistered bouncers to attend training colleges so that they can register with SERA. And this will in turn provide opportunities in terms of salaries and employment benefits. And also another important factor to consider when thinking about enforcing the bouncing industry is to create a credible industry that is trustworthy. The bouncing industry is notorious for violence and other criminal activities. The Cape Town nightclub security wars that occurred in the recent years is a perfect example of this, where security companies were battling to gain control in numerous nightclubs in Cape Town in order to sell drugs and engage in other illegal activities. And in 2012, a popular company that operated in a majority of nightclubs in Cape Town was reported by SERA to be operating illegally because it was not licensed. This seems to be a trend in this space of the bouncing industry. So this industry obviously lacks credibility, and this can be attributed to lack of enforcement. Regulating this industry efficiently can also mean that enforcement and compliance will be achieved. The SERA developed two important departments within SERA that ensured compliance of private securities with the law. So efficient regulation would mean that most, if not all, bouncers are trained and registered with SERA, and that SERA ensures that bouncers comply with the SERA Act when executing their duties through oversight and monitoring. And a space that is this dangerous, that is as dangerous as drinking establishments, can do with well-trained, qualified, and competent bouncers. And as a result, it will lead to better conflict management and possibly less violence in drinking establishments. So what is the role of SERA in drinking establishments? As colleagues have mentioned, that SERA is the current regulatory structure mandated to monitor and regulate all the private security industries in South Africa. It was established in terms of sections of the SERA Act, and according to the Constitution, the SERA Act is subject to promote a legitimate private security industry, which acts in terms of the principles contained in the Constitution and other applicable and relevant laws. And also to promote a private security industry, which is characterized by accessibility, equity, accountability, professionalism, and also transparency. So SERA has developed two departments in order to assist with regulating the industry, which are the compliance department and the enforcement department. Both departments are ineffective, to be honest, when it comes to overseeing and monitoring compliance and also enforcing regulations on bouncers in drinking establishments. The compliance department should ensure that the industry is aware of the rules and take necessary steps to comply with the rules and regulations governing the occupation of bouncers. In my PhD, I interviewed one compliance officer stationed in KZN, and he alluded that it is a challenge to monitor bouncers at night because they work from 7:30 in the morning until 4 p.m. And only on Monday to Friday. However, bouncers in most cases work at night and during the weekend. So that is how they miss each other and end up not being able to oversee and monitor bouncers and drinking establishments. And in addition to this, SERA has to also rely on the SAPS for backup and assistance. And sometimes it seems like there's no clear communication between the SAPS and SERA to assist with overseeing and monitoring of drinking establishments and bouncers. And the enforcement department deals with security service providers who evade compliance. In my study, I found that drinking establishments were the one who directly hire bouncers instead of hiring private security companies that are SERA accredited. So they avoid hiring legitimate private security companies so that they don't have to pay a large amount of money on security. The requirement of being a bouncer in these nightclubs mainly revolves around masculinity. A bouncer should have muscles to qualify as a bouncer, which is an incorrect requirement. And the enforcement department is paramount because they do inspections, and if non-compliance is found, investigations occur and possibly a criminal charge will be applied. So this action can enforce bouncers.
Sorry to interrupt. Can you please wrap up?
Okay, thank you. I'll just wrap up just now. So this action can enforce bouncers and drinking establishments to comply with the SERA Act. So in my study and what I've observed by conducting this study, I've made some recommendations, and one of the recommendations that SERA can apply is to employ more staff to assist with oversight and monitoring bouncers in drinking establishments. And with more staff employed, that means more oversight and more monitoring can be conducted regularly. And also to develop a suitable working relationship and agreement with the SAPS to assist with oversight and monitoring of bouncers. Also to provide harsher punishment for non-compliance. This will ensure, this will surely be a motivator for those who do not comply to comply with the law. And also to educate drinking establishments and also bouncers on the rules and regulations of SERA so that they are aware of the processes and procedures that are legally recognized within their space of function. Thank you.
Thank you so much, Mr. Mbele. Up next is Ms. Londiwe Xaluza, a junior researcher from SERA. Her topic is on the private security industry and student protest in South Africa. You can go ahead, Londiwe.
Good morning to my esteemed colleagues from UKZN and from SERA, and good morning to all the attendees of this webinar. My name is Londiwe Xaluza, and I am a junior researcher for SERA. I will be doing my presentation on the research report titled Barriers for Control, the Private Security Industry and Student Protest in South Africa. I think, sorry. Before I begin with my presentation, I would like to state that this report was authored by one of our former colleagues, Ms. Margaret Kichanga, who is currently pursuing her PhD studies in the UK. The presentation overview is as follows. I will first present on the research background, which will state why the authority undertook the study. And then I will follow on the findings of the research and then the research recommendations. In 2016, there was the Fees Must Fall protest that took place in almost all institutions of higher learning. This was due to the 8% increase that was announced by the Minister of Higher Education on the fees of university or let me say institutions of higher learning. Although it is a constitutional right to protest, the Fees Must Fall protest brought about great concern because there were a lot of distractions, or let me say there was a lot of destruction to university or institutions of property, institutions of higher learning, property and assets. Hence, the management of these institutions then involve the private security industry, either by hiring them or using their own in-house security to protect these infrastructures. There were many complaints laid against the private security officers, as we had all seen on television that they had manhandled some of the students and beating them up, which is a violation of one's human rights. CIRA, which is mandated by the CIRA Act of 2001 to regulate the private security industry and exercise effective control over it, then decided to do a research study looking at the role of security, or let me say security officers in protest, and to see if we are mandated as the private security industry to even partake in some of the functions that are needed when there are protests. The research findings are as follows. The research found that many of these security officers or private security officers were compelled by their clients to act beyond their scope. Moreover, sometimes security officers were left alone to control or to deal with the riots because they would have meetings, or meetings would be scheduled with management. However, they would not come to party and discuss what security measures could be put in place in order to protect infrastructure. There was also abuse of powers by security service providers who then started acting beyond their scope by providing services such as crowd control, which we all know, or let me say, which is a security feature only mandated to the public order policing units within the police. Another thing that was found, or let me say another finding that was found by the research is that there were some, or let me say there were two security or private security companies that were accredited to do crowd control training, which was a huge concern because the requirements for accreditation to do crowd control are unknown. And more especially, as I had, let me say, stated earlier, crowd control is only designated to a certain unit within the police. There was also the use of fraudulent security guards during protests. These included security officers who were not registered with CIRA, and some of them being foreign nationals or undocumented foreign nationals. There was also the use of uniform and insignia resembling that of state police. So these private security companies were creating the impression that they were state police in order to scare students. The study recommends that SIRA should consider prescribing qualifications that are applicable to the protest environment. However, these qualifications should be a complement to what the South African Police POPs unit are doing, or let me say, they should not imitate what the police are doing. And private security companies that create the impression of being police during protest or any other state services or security services should succumb to stricter penalties, as the SIRA regulations or regulations 13 prohibit private security companies from using uniform that resembles that of state security. And I have come to the end of my presentation. Thank you very much. And if you would like to read on or read this report or other reports that we have published, there is a link available below which you can go, and then you will see some of the research reports that we have done as SIRA Research and Development Unit. Thank you very much.
Thank you so much, Londiwe. That was a good presentation. So now I'm going to be, I hope all the panelists are reading the questions on the Q&A. I will be taking questions from now on. If you have anything that you want to add, if you want to comment, please write on the Q&A. I will be reading the questions, and then anyone from the panelist list that wants to answer, they can tackle the following questions. One is from Ntokozo Mavundla. Basically, his question is, what is SIRA doing in relations to the exploitation of security personnel within the industry?
Thank you. Sorry, Director, you want us to, are we going to take all the questions first, or are we going to answer each question as it comes? Just wanted to get direction from that part.
Sorry?
I just wanted to get a direction whether, are we going to answer all the questions, or maybe get all the questions first and see which ones are relevant to each personnel, or should we answer as they come once you raise the question?
Okay, can we answer as we go? So if anyone wants to tackle the first question, and then we move on to the next one.
Okay, no, maybe in respect to the one that you asked, exploitation of labor, it's I think it's too broad. What has happened now, we've got the National Bargaining Council that has been brought into the private security industry that will deal with all the contents of the bargaining agreement that deals with wages and salaries. So what we do as the authority, matters that deals with wages and condition of employment, once we receive, then we will refer the matters to the National Bargaining Council to look into that. But other methods of exploitation, let's say where someone is used and is not registered or is not trained, then those are purely also contravention of the code of conduct. And once we receive that as the authority, through our enforcement or compliance inspectorate, that will conduct an inspection to that security service provider. And if that is found to be true, then we'll compile a code of conduct docket. That's where a business will also now receive a charge sheet where they will have to come before a tribunal, which is constituted in terms of the improper conduct regulations, and penalties will be imposed there. Also, as I indicated, those on that slide, it may be imposition of a fine to an amount of 1 million or withdrawal of registration. So, but matters that are dealt in terms of the bargaining council, also I think the employees, they can also refer such matters if maybe the bargaining council, the decision is not coming up there to the CCMA, because the CCMA is still empowered in terms of the bargaining agreement and other level legislation to deal with those exploitative methods of employers. Thank you.
Thank you so much, Mr. Sambo. The next question is basically, does CIRA have a working relationship with CCMA as a way of ensuring that security personnel are not mistreated within the industry?
To answer that, on my slide, there was a slide where I talked about also what we do as with national bargaining agreements that are coming. So maybe let me answer to say yes, or it depends. If maybe the ruling of the CCMA requires an intervention by CIRA, and also look into that, whatever ruling it is, it's within our scope, then we will certainly enforce that. So yes, we do work with CCMA because they are also a party to our, we've got a forum where we call it a PICF, Industry Compliance Forum. So CCMA is also a stakeholder there. So whatever is happening in their space and which affects us, then we working together with them to make sure that there is compliance. Thank you.
Thank you. A question for Tebogo. Tebogo has mentioned a course which is available within some university institution. How can one be able to access such courses, and what are the requirements for these courses? Tebogo?
Yes, thank you, Norma, for the question from a participant. Ordinarily, when the course is about to start, the University of Witwatersrand, specifically the Mandela Institute, will indicate the dates on which the course will start and ends, because it is a block program course in which you are given a chance to attend at a particular time and be able to stop at a particular time. So ordinarily, the University of Witwatersrand put the adverts on their website to say that at a particular moment, the course will be starting and it will end at a particular moment. But furthermore, they can still engage with us as the research and development unit, because ordinarily when the course is about to start, we know that the course is about to start at a particular moment, and the registration and other requirements are dealt with by the University of Witwatersrand in itself. As I indicated, it is a postgraduate course, which gets to say you need to have a certain qualification beyond matric in order for you to be able to register for that course. I hope I have answered the person who asked the question, Norma.
Okay, thank you, Tebogo. The next question is with regards to training qualifications for employees. CIRA currently recognizes a grading system from A to E. Are you planning on migrating this to qualifications that are offered in tertiary education bodies? I think you've answered a part of this question from your previous comments.
Okay, maybe maybe on this question, I don't know, I'll take a part. When we talk about training qualification for employees, maybe in the security industry or maybe CIRA employees, maybe let me take first. Within the industry, we've got, I think basically the industry has been known as guiding for guiding purposes, but that has changed totally as the presenters and what our CEO, Mr. Stefan, indicated on what type of services are we regulating. So yes, in certain areas, the minimum requirement will still be a grading in terms of grade E to A, depending on what type of services are you doing. Let's take, for example, someone who's doing access control, then you will need that person to have grade E and D, and maybe also depends on what type of access is he doing. There may be other requirements. someone who's doing control or operation services, then you will need that person should be trained in the use of CCTV and other equipment. So, and certain areas like close protection, your normal grade sometimes may not be enough. Then you may maybe experience and other form of training that it may be required. Like, for example, you will need to carry a firearm, so you will need a qualification or training in respect of firearms. But what I may say is majority of requirements in respect to security has been more occupational training because of the era where we're coming from, but that is more changing. And I saw maybe on the chat there's been a question, maybe let me answer one on that, on what form of qualification is needed to be a SIRA employee. Talking maybe more especially within our division as inspectorate, most of the requirement that we need, you need that person should have a post-matric qualification, and more relevant within law enforcement and investigations, because majority of our work that we're doing is more of investigation of complaints. So that's what we require, that either being a national diploma or degree within law enforcement, investigation, and law. That's what we're looking for in most cases in respect to inspectorate. But within law enforcement, as I indicated, we've got prosecution. So where a degree in law will be required and an experience as being a prosecutor, or that will act sufficiently for one to be a prosecutor. Thank you.
Tebogo, you noted.
Yes, Norma. In addition to what Mr. Sambo has just said with regard to the question that was answered, it was asked by a participant, where in which they wanted to know if are we going to migrate from the grade system into acknowledging other qualifications that are SAQA registered or SAQA recognized. We have a recognition prior learning system where in which an applicant can bring in their qualifications of which they think they are necessary for them to be registered, and the registration subcommittee will make a determination with regard to that. But as to migrating entirely to register only those that are having formal qualifications beyond matric, I don't think that is where SIRA wants to go at the moment. Reason being that in terms of Section 3, the objects of the authority, amongst others, the authority has got the responsibility to encourage ownership and control of security businesses by persons historically disadvantaged through unfair discrimination. And also the authority has got the responsibility to promote the empowerment and advancement of persons who were historically disadvantaged through unfair discrimination in the private security industry. And you will almost all certainly agree with me that those people who were previously advantaged are particularly African Black people, and most of them will not necessarily have a post-matric qualification which is recognized by SAQA. So we are not trying to chase people away in as much as we want to improve, but there is also a legislative mandate that we have to ensure that we accommodate people who were previously disadvantaged. And that is a legislative mandate that we cannot run away from. Thank you, Norma.
Thank you. Thank you, Tebogo. Another question is to Mr. Tebogo. Police officers have insurance from their employers that covers their members where there is fatality in duty. What about private security officers? If none, what are the future views of SIRA on this matter?
Can I answer that? Maybe Tebogo will add.
Oh, okay, that's fine.
Okay, thank you. Remember what I think what our Stefan covered, and it's apparently in the industry, it's the contract of rendering security service is between a security service provider and a private person, that is the landlord or the owner of the premises which you are covering. So what has happened in the industry, it's there's been a demand by security by the consumers that, you know, when they contract type of security, then they'll request that there should be sort of public liability insurance that a security service provider has to procure before they are appointed, and that you know, that will go into a long way into making sure that any form of actions that is performed by the security officer which may result in a delict or any liability, then that service provider will be able to in a position to cover that. And also the authority is moving to a situation where we'll have a sort of a guarantee fund that is being, I think, on the process. The COO could have covered that in his presentation, where now once it's introduced, then all form of liability that there will be a contribution that will be made by the security service providers to the authority, and that will be covered. They will be covered in a form of liability if there will be something like that. So there's something that is happening, but currently the form of public liability that is required by the consumers of security from service providers before they contract them. That's what is actually taking place currently. I hope Teboho will add if maybe there's anything else that he needs to cover on that. Thank you.
I trust the question has been fully answered, Norma and Mr. Sam. You put it very much well.
Oh, okay, thank you, Teboho. Our last question, can you comment on the judicial and regulatory overlaps between the newly informed National Bargaining Council for Private Security and CIRA?
I don't think there's an overlap. The bargaining council, it's there to make sure that the agreement that has been signed and that has been extended to the non-parties, it's enforced within that. So all that they do, I think they found their powers and their jurisdiction in respect to the conditions or the elements of the bargaining agreement. But whereas with CIRA, our function is totally, we are an enforcement agency, which the bargaining council is not. So our powers is derived from the Act and any applicable legislation that is within the industry. So it's a two. I think those are two cases which we cannot compare. Yes, what they are enforcing in respect to the agreement is something that we've been doing before they came into existence. And overall, what they do, I think they will enforce it, you know, to the down level, like for example, look into issues of overtime, payment of Sundays, all those things. But as the authority will be looking at the conditions or the remunerations is paid by security service providers, so it will be a more broader situation rather than to get to, you know, all basic elements of that. So we still in control as the regulator, and then no, that is enforced, or that is I think is confirmed by legislation, the CIRA Act, and the mandate that we are carrying as the authority. But maybe if you allow me, I just wanted to just give a comment from the presentation that was made by Mr. Mbele and what has been covered there. I think yes, the bouncing industry, just like the car guards, there's been some industry where, you know, there's not been so much clearness maybe from the public, and the recommendation that he made are very welcome. And maybe to answer to that, it's I've covered also on my presentation that I think the cooperation and the challenge between us and the South African Police Service, somewhere also the NPA would result in this situation where you know, you find that there may not be more enforcement coming to that part. But what is nice, I would say, is as the authority, we are establishing a task team, which will be once it's established and all the powers received, will be targeting areas like that. You know, I think the Cape Town underworld and what you've observed in KZN, I've done that, and then we'll be able to deal with it. But I just want to distance myself to maybe the comments that was made by our company working from 84. We are an enforcement agency which, you know, crisis need to act on that. So that I really, to tell as head of law enforcement, distance myself with that. We've been operating beyond 84 for as much as I remember being within law enforcement. And then what is very important is, as long as we've got planned operation with the South African Police Service, with immigration, any time of the year or of the day, we are being able to enforce that. So that is going to happen once the task team is in place. I think our operations will be more bigger, and getting that cooperation through the forums that we are having with SAPS and the NPA, then we'll make sure that industry, there's awareness from com side, and also our self-assessed enforcement. We enforcing the legislation equally to all the South Africans. I thank you.
Thank you, Mr. Sambo. Now I'll be handing over to Dr. Mkhize, our academic leader, for closing remarks. Dr. Mkhize.
Thank you, Chair. Greetings, everyone. I'll be very quick. On behalf of University of KwaZulu-Natal, Criminology and Forensic Studies discipline, and all the attendees, I would like to extend a hearty word of thanks to all speakers. This is for gracing your important work and sharing with us your findings and opinions today. Your presentations were highly informative and provided a number of ideas. We really appreciate hearing about CIRA and what CIRA is all about, as many of us had limited information about CIRA. We also believe our institution and our discipline will benefit from the skills that will be provided by CIRA. As you know, we are currently in discussions regarding working together, so our partnership. Hopefully, all the formal processes will be finalized soon so that we can start working together. Obviously, an event like this cannot happen overnight. The wheels started rolling weeks ago. Thus, I would also like to thank all the organizers of this webinar. This is really appreciated. And lastly, a big thanks to all the attendees. Thank you very much, and have a good day. Thank you. Over to you, Chair.
Okay, thank you, Dr. Mkhize. I guess that's all for today. Thank you everyone for attending. I will hand over to Professor Del now.
Good afternoon, I think it's almost afternoon. Thank you everyone for attending and for sharing your ideas and your knowledge. And I wish you